This is Bloomberg Law with June Grasso from Bloomberg Radio.
Yesterday, a federal judge temporarily blocked President Trump from ousting Federal Reserve Governor Lisa Cook over allegations of mortgage fraud. An order that allows Cook to attend a highly anticipated Fed policy meeting next week to vote on whether to lower interest rates. Today, the Trump administration appealed that order to the D.C. Circuit Court of Appeals. Joining me is Bloomberg Intelligence senior litigation analyst Elliott Stein. Elliott, federal judge Gia Cobb found that Trump likely violated the Federal Reserve Act and Cook's due process rights. Start by telling us about her reasoning under the Federal Reserve Act.
Sure. So on that issue, she said that the for-cause standard wasn't met because even though it's not defined in the statute, based on the history and the context around its insertion into the Federal Reserve Act, it suggested strongly that cause requires some sort of event while the person is in office that can affect how they carry out their duties in that role. And in this case, she said that wasn't met because the allegations pertain to conduct in 2021 before Lisa Cook was confirmed to the Federal Reserve Board.
The judge said, moreover, it would incentivize the president and subordinates to dig up prior conduct, however insubstantial, to justify removal from the board, even where the board member has been up to that point performing their statutory duties impeccably. Was that sort of a shot at what happened here, where Federal Housing Finance Agency Director Bill Pulte dug up these allegations from mortgages that Cook obtained in 2021?
Yeah, I think that's a fair interpretation. And in other parts of the opinion, Judge Cobb said, cause can't mean sort of vague, unsubstantiated allegations without any form of investigation. But I thought what was interesting in the opinion was that Judge Cobb did say there could be circumstances where the conduct at issue takes place before the person is in office, but then let's say that person is convicted while they're in office. Judge Cobb suggested that conviction could meet the for-cause standard. So, that scenario could also incentivize people to dig up dirt from years ago. So I'm not really sure that example that Judge Cobb used would eliminate the possibility of, political opponents trying to dig up dirt.
Did she comment at all on the explanations from Cook's lawyers that if there were any errors, she didn't mean to deceive anyone, no one was harmed, and perhaps that even this was a clerical error?
She did sort of allude to that, I think in a footnote, if I recall correctly. But that sort of goes to the due process part of the opinion, right, where Judge Cobb said that in addition to the statutory violation, there was a constitutional violation because Lisa Cook didn't get proper notice or an opportunity to be heard before she was removed.
And so the judge was saying that finding out from Trump on social media was not enough?
Right, exactly. Yeah, that went to the notice part of the equation, and then, an opportunity to be heard also has to be satisfied, and for that there has to be some sort of formal hearing, essentially, and Judge Cobb cited to other cases where officials were removed for cause, and there usually was some sort of formal hearing where the official could present their side of the story.
Tell us a little bit about Cook's allegations that Trump's move to oust her is politically motivated.
Cook's point is you can't separate the allegations against Lisa Cook from the months of accusations against Jerome Powell and then other comments President Trump has made about trying to gain a majority on the Federal Reserve Board. And so that's the context that Lisa Cook is pointing to as to why she thinks the mortgage fraud accusations are a pretext, just trying to remove Federal Reserve Board governors for policy disagreements, essentially, because even the Trump administration conceded that you can't satisfy the for-cause requirement by removing someone for a policy disagreement.
So that ruling came down yesterday, and today already the Trump administration is appealing.
Yep, no surprise there.
No surprise, but have they stated their grounds for appeal yet?
So I've only seen the notice of appeal so far. I've been trying to refresh the docket to get...
As many others are.
Yeah, I've been refreshing that frantically. And this will go to an emergency motions panel on the D.C. Circuit. It seems from a different case where I was able to track down the emergency motions panel in that case, it seems like it'll be a favorable panel to Lisa Cook in the sense that it's a Biden appointee and an Obama appointee, and then a Trump appointee. So sort of two judges that are probably going to be more sympathetic to Lisa Cook's arguments. And then from there, assuming the government loses at the D.C. Circuit panel stage, I presume the administration will go to the Supreme Court.
The Fed board meeting, the highly anticipated Fed board meeting,
right.
So Cook will be able to go to that meeting if this decision is upheld.
Right, yeah, exactly. Unless this decision is stayed, she will serve at that meeting. And I do think it's possible that the D.C. Circuit Emergency Motions Panel can rule by then. And again, if it's a favorable panel to Lisa Cook, as I suspect it will be, I don't envision Judge Cobb's decision being put on hold, in which case Lisa Cook would be able to participate at that meeting. I don't think we'll get anything from the Supreme Court by the September 16th date unless the D.C. Circuit moves even faster than I think they're going to.
I mean, it's possible.
It's true. You could get a D.C. Circuit panel ruling on, let's say, Monday the 15th, and an administrative stay by the Supreme Court like the next day or even that day. So it's not out of the realm of possibility, but I still think the more important dates are in February, not next week. Because next week, Lisa Cook's only one vote out of 12, and I don't think it'll make all that much of a difference. But in February, if President Trump can get a more favorable balance on the Federal Reserve Board, let's say he's able to move Lisa Cook out of her role and Stephen Miron get confirmed, as he's expected to, you could potentially have a 3-3 balance on the Federal Reserve Board, 3 who are sympathetic to Trump and 3 who aren't. And at that point, you may not get the regional Reserve Bank presidents reappointed in February, in which case you potentially could get a shift on the FOMC in a direction that's more favorable to President Trump.
And what are the odds of Cook prevailing when this does get to the Supreme Court? When? I think when is a safe bet.
I mean, I think it's an extremely close case, but I do give her the slight edge. At the Supreme Court, the 3 justices appointed by Democrats are likely to rule in her favor because they'll be more concerned about Fed independence and be more concerned about an expansive executive authority. I think Justices Thomas, Alito, and probably Gorsuch are more likely to rule for President Trump. And then you have sort of the 3 who have now become the middle in Roberts, Kavanaugh, and Amy Coney Barrett. And, at that point, Lisa Cook needs to get 2 of them. And I think she has a pretty good shot at that. Justice Kavanaugh in the past has written in opinions concerning the 4-cause removal restriction that he's hinted strongly that the Fed is different from other agencies, similar to what the Supreme Court said in May in the Wilcox decision. And given that they do seem to distinguish the Fed from other agencies, they have to give some sort of effect to the 4-cause removal restriction so that it's not rendered meaningless. And with that in mind, I think they probably would agree with parts of Judge Cobb's decision that the 4-cause removal restriction has to mean something and that the mere allegations here didn't meet it.
And Elliott, has the Fed made any more statements since the judge's decision?
I haven't seen a statement today. I may have missed one. I know in the past they said they would just abide by the court decision, which makes sense. And that's essentially why Lisa Cook named Chair Powell and the Federal Reserve Board, both individually and collectively, as defendants, because in Judge Cobb's ruling, she essentially enjoined the Federal Reserve Board from effectuating President Trump's termination letter. I don't think the Fed has to say anything other than simply abide by the decision.
So we'll see now how fast the D.C. Circuit Emergency Panel acts. Thanks so much, Elliott. That's Elliott Stein, Bloomberg Intelligence Senior Litigation Analyst. Coming up next on the Bloomberg Law Show, Later this month, Chief Justice John Roberts celebrates 20 years being the chief. And in that time, the Roberts Court has moved far to the right, changing the law in areas from abortion and guns to race and presidential power. I'm June Grasso, and you're listening to Bloomberg. Chief Justice John Roberts famously compared judges to umpires during his confirmation hearings in 2010.
Judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire.
Now, 20 years later, looking at the court's decisions under Roberts' stewardship, just applying the rules in a limited role doesn't seem to have been the practice of the Roberts Court. With its conservative majority and now supermajority, the court has changed the law on abortion, gun rights, religious rights, race, agency authority, and presidential power, overturning precedent along the way and moving more and more to the right. My guest is constitutional law professor Eric Segall of Georgia State University. Let's start with the court itself. Is the Roberts Court the most conservative Supreme Court in our history?
You know, it is challenging to compare across decades. And also, I think, to some degree, what is conservative is in the eye of the beholder. It is certainly the most conservative court of my lifetime, which is 67 years. You know, if I was living in 1934, I would be very mad at the Supreme Court if I was a liberal or a progressive. They were really mad at the Supreme Court, so much so that FDR went on the biggest media of the day and said we have to save the country from the court and save the Constitution from the court. So it's a little difficult for me to say liberals and progressives today are angrier than liberals and progressives were in 1934 when the New Deal was a catastrophe for America. It is certainly as conservative as any court, I think, in American history.
Roberts famously said during his confirmation hearing that judges are like umpires. Umpires don't make the rules, they apply them. Has he behaved like an umpire?
Well, Justice Kavanaugh repeated that years later as well, despite the mockery and laughter of virtually all court watchers, pundits across the political spectrum on that statement by Justice Roberts. They're not umpires. They've never been umpires. In 1857, Congress wanted to end slavery in the territories. Congress had the power to do that under the Constitution. The court made up a new rule and said no. And from 1900 to 1936, the court struck down hundreds of laws about minimum wages, overtime rules, labor conditions. The Constitution allows Congress to do that. The court wasn't playing like an umpire. And I think conservatives would fairly say that cases like Roe versus Wade were not the justices acting like umpires. So no, it was a silly statement when he made it. It was even sillier for Justice Kavanaugh to repeat it during his confirmation hearing. The Constitution is a very vague document when it comes to litigation. There are some specific things. The president has to be 35, 2 senators from every state. Inauguration day is January 20th, which, by the way, is too long from November. But we don't litigate those clauses. We litigate due process, equal protection, cruel and unusual punishment, unreasonable searches and seizures, and so on. It'd be like saying to an umpire, you get to decide what's fair in a baseball game. That's not what umpires do in baseball. They have some discretion, of course. We've told the Supreme Court, in effect, make the constitutional rules for America, and that has nothing to do with sports umpires.
There are a lot of areas where the Supreme Court has changed or reshaped the law. Most people know about abortion rights and gun rights. But how has the court changed the law around race? And what's been Roberts' role in changing the rules?
Other than the presidential immunity decision in Trump versus United States, which almost no legal scholars predicted liberal, moderate, or conservative, and is one of the worst opinions in Supreme Court history, in my opinion, and many others. Leaving aside that opinion written by Justice Roberts, I think he's done the most damage to America when it comes to race. And it started in his very first term, when the cities of Seattle and Louisville, let's take Louisville for a minute. Louisville had segregation under the law for many, many years. Those schools were still segregated. So at the very local level, students, and teachers and parents and school board members and voters got together and came up with a very limited plan to make sure that the public schools in Louisville had some minimal degree of desegregation so that white kids and black kids in Louisville could go to school together. And no judge ordered this. This was voluntary. And in his very first term, the Roberts Court struck that down. And that's when Justice Roberts said the famous line, the way to stop discrimination based on race is to stop discriminating based on race. In the context of Louisville, Kentucky, which discriminated on the basis of race legally for a century, that's, in my opinion, a very bizarre statement. And even Justice Kennedy, who was the fifth vote in that case, disagreed with that statement. So it started there. Everybody knows that Justice Roberts does not like voting rights. As a young attorney in the Reagan administration in 1981, he wrote some scathing things about the Voting Rights Act. And then, of course, in Shelby County versus Holder, he was able to concoct a new rule that Congress can't treat different states differently without a strong reason, and struck down a law that was passed by a unanimous Senate and signed by a Republican president. That law was struck down, and then the very next day, Texas and North Carolina passed voting rules they could not have passed prior to that law being struck down. They've also interpreted the Voting Rights Act very narrowly, and I think this next year even more narrowly again. And then, of course, there's the affirmative action case, which overturned 50 years of precedent and said colleges and universities are not allowed to use race at all in their admissions processes. It's as if Justice Roberts thinks America started in 2006 when he became Chief Justice, or maybe 1981 when he was an attorney for the Justice Department, and race was never a problem in this country. It's as if he thinks we can just snap our fingers and all of our racial divisions will go away, when all the data shows that Black Americans today economically are really not any significantly better off than they were 20, 30, 40, 50 years ago. And our justice system is infected with racism. And Justice Roberts has really turned a cold shoulder to dealing with those problems.
You mentioned presidential immunity and that decision, which I agree no one predicted, and which was written by the Chief Justice. How has it changed the powers of the president?
I'm teaching that case tonight, and I had a little bit of a new observation this morning about that case. It's a little bit wonky, but some people remember that a Supreme Court with 9 Democrats in 1952 told a Democrat president, Harry Truman, that he couldn't seize the steel mills in time of war. That's 9 Democrats. 6 of them voted, you can't do that, Mr. President. And he said very serious things about why he wanted to do it. And in that case, there's a famous opinion by Justice Jackson, again, a little bit wonky, but not really, where he divided these kind of cases into 3 categories, where Congress tells the president he can do something, where Congress tells the president he can't, and a twilight zone in between. Now, on Justice Roberts' immunity decision, it occurs to me that he thought he was doing something statesmanlike. That case had 3 buckets, and that case is still good law for official action, and that case is known as one of the most important cases in separation of powers history. Justice Roberts divided presidential immunity into 3 buckets as well. For actions that he takes in his core executive functions like commander-in-chief, he's absolutely immune from future criminal prosecution. For unofficial conduct, private conduct, he has no immunity at all. If he goes out to a bar, drinks, and punches somebody, he has no immunity. For things that are in between that, where Congress has authorized him to act or we're not sure if he has the authority, he has a strong presumptive immunity, but that will depend on the facts. It's 3 categories, and I think he is trying to mirror what Justice Jackson, who's a very popular justice among all people, liberal, conservative, and moderate, was trying to do. And if he had stopped there, I think we all would have said, okay, that kind of makes sense. But he didn't. They added 2 wrinkles, and this was 5 justices. Amy Coney Barrett did not agree with this. He said, how do we distinguish between official conduct and unofficial conduct? And what he said was 2 things. You can't question motives, and you can't use obviously official acts to prove unofficial acts. Those 2 evidentiary rules make the president effectively immune from prosecution. Real quickly, if the president and the attorney general are walking down the street and they see Segall walking down the street and they say, you know what, he's a national security risk, and a president takes out his gun and shoots me in cold blood. After he retires from the presidency, they prosecute him for murder. His motive for shooting me cannot be examined. So when he says, I did it for national security reasons, we're done. The Attorney General might testify that's not why he did it. He did it because he doesn't like Segall. That testimony doesn't come in because testimony about the evidence that he has with his advisors about any kind of conduct is basically inadmissible. All of that's a long way of saying puts the president above the law. And there is no effective way to criminally prosecute a president unless the conduct, well, even if the conduct is unofficial, he's going to say he had an official reason for doing it, and we're not allowed to talk about his motive. That's what confused everybody. And that's a real problem going forward. I was shocked the other day when an interviewer asked Justice Amy Coney Barrett, who's doing her book tour, if the president ordered SEAL Team 6 to kill a political rival, would that be immunized by the Trump decision? Now, in any sane world, the answer would be, of course not. The president can't go around ordering the SEALs teams to kill his political rivals. And so she should have said, of course not. But what she said was, I don't know. And that's the country we're living in right now. And that's the effect of the immunity decision. And that's just really a shame.
And looking at the emergency docket, or the so-called shadow docket, the Supreme Court has sided with the administration in almost all the emergency cases since January on everything from mass federal layoffs to banning transgender people from the military to lifting restrictions on immigration stops. Even though administration officials have been so critical of federal judges and went so far as to sue the entire bench of federal judges in Maryland.
I don't know what's happening. It is my view that Supreme Court justices are and have always been ideological. If you had life tenure and effectively unreviewable power, if you got 4 of your committee members to agree with you, or court members, you would impose your ideology, and so would I, when we felt strongly about it. But the court has not always been partisan. The Casey decision, which affirmed Roe versus Wade, had 7 Republicans. I just mentioned that a court with 9 Democrats told a Democrat president, you can't do something during time of war. So the court's always been ideological, but not partisan. The Roberts Court, from the very beginning, its overwhelming ideological value is partisanship. They want to help the Republican Party. And almost everything they've done can be explained if you see the court through the lens of an institution that is trying to help the Republican Party. And so this doesn't surprise me at all what's happening. Some of us thought maybe because Donald Trump was president, the court would be less partisan than it has been. If anything, it's been more partisan this time around, without giving us reasons, as Professor Steve Vladeck has repeatedly pointed out in his book, The Shadow Docket, and on other places. They don't give us reasons for many of these decisions. And we must remember, 3 of these people, represented George Bush during Bush versus Gore. They all came up through core Republican Party ranks. And I will say the 3 Democratic nominees also favor Democrats. But usually there's a balance of values between partisanship and personal ideology. Justice Kennedy famously voted for gay rights. Justice O'Connor kept affirmative action alive. Justice White, a Democrat, voted conservative many, many times. These justices are Republicans first, foremost, and almost always, which doesn't mean Republicans always win, because the court sometimes wants to throw people a bone, and also because on little issues, they might disagree with the Republican Party platform. But on all the big issues, this is the Republican court.
Coming up next, is Roberts really an institutionalist? This is Bloomberg. I've been talking to constitutional law professor Eric Segall of the Georgia State University about Chief Justice John Roberts celebrating 20 years as Chief Justice come the end of the month, and how the Roberts Court has changed the law. Roberts did write the opinion saving Obamacare, and in the Dobbs decision, he wouldn't have gone so far as to actually overturn Roe v. Wade. So is it Roberts that's moving the court to the right, or is it the presence of the 3 Trump appointees that gave the conservatives a supermajority that the liberals just can't fight?
There's no question that those 3 Trump appointees have played and will continue to play a significant role in moving the court far to the right. But it's also a little bit of a myth that Justice Roberts was ever anything less than an extremely conservative justice. Yes, he did save part of Obamacare Remember, he did not save the Medicaid part of Obamacare, which was actually a key part of that law. And by striking down that part of the law, the court did serious damage to Obamacare in complicated ways that health policy experts could explain. Now, when I say that in public, people often say, but that was 7-2. But we all know from reporting done that Justice Roberts coerced Kagan and Breyer to join that part of the opinion. So he did save Obamacare as a whole, but he cut out a big part of it, which really hurt that law. Before 2012, in the 7 years preceding that case, he had never joined with the liberals in a 5-4 opinion. Since then, he has done it. He's joined with liberals a few times, and you're right about Dobbs, but there is no question that he would have eventually voted to overturn Roe. Justice Roberts' formula has been consistently in voting rights, race cases, and abortion cases, and separation of powers cases. Punch holes in the precedent, then reverse the precedent. There is no doubt he would have eventually voted to overturn Roe versus Wade. So I think even a 5-4 court run by Justice Roberts would be an extremely conservative court. And with the exception of Justice Kennedy's votes on affirmative action and gay rights, was an extremely conservative court for most of Justice Roberts' career.
So then do you buy the theories that Roberts is an institutionalist and an incrementalist?
He is an incrementalist in strategy. He is absolutely not an institutionalist. And I, in fact, wrote an article for the Wake Forest Law Review saying that this is going to sound personal, so I apologize to your listeners if it sounds personal. It's not. I'm just kind of a scholar trying to figure things out. Justice Roberts leads with hubris. The way to stop discrimination based on race is to stop discriminating based on race. His statement is one of the most hubristic statements I've ever heard, because I don't know how to solve America's racial problems. Frankly, you don't know how to solve America's racial problems. I don't think Justice Roberts knows how to solve America's racial problems. They're complex. Maybe affirmative action is good. Maybe it's bad. I'm not an expert on that kind of thing. I'm an expert on constitutional law. But the idea that simple statement captures all of the complexities is full of hubris. His striking down of the Voting Rights Act based on a principle that was completely inconsistent with a major Supreme Court precedent from 1965. Again, a law passed by a unanimous Senate, signed by a Republican president, was full of hubris. And his separation of powers decisions, and he is the person who normally writes them, where he is telling the Congress, you're not allowed to limit the ways the president can fire the heads of independent agencies, is overturning precedents that go back to the New Deal and changing the way the American governmental system works. That's not what umpires do, and that's not what an institutionalist does. I don't think he's an institutionalist at all. I do think he's an incrementalist as a matter of strategy, not as a matter of substance.
Another area where there seems to be a lot of activity lately and more changes to come is federal regulatory authority. Tell us a little of what's been happening there.
So in November of 2016, after President Trump was elected the first time, I wrote an essay saying that he's going to appoint justices if he gets the opportunity to overturn Roe, because that was a campaign promise. But I didn't think President Trump really cared about that. What I wrote was he wants to end the regulatory state, the administrative state, meaning most of the laws that govern American private conduct and companies, environmental regulations, food and drug regulations, they all come from the executive branch. Congress passes a very broad law saying pollution is bad, president, go fix it. Congress passes a law saying we want to have safe food, everybody wants safe food. Executive branch, you go ahead and fix that. Well, Donald Trump's a businessman who doesn't like regulations. He appointed 3 justices who don't like regulations, and they are doing everything they can to make it harder for the executive branch to pass regulations such as environmental and food and drug laws. And it's very hard for Congress to do it because they don't want to politically take the hit. So it's not a surprise that this Supreme Court is trying to really go back to a 1930s pre-New Deal understanding of federal power over the economy, because these are people who believe, in a totally free marketplace, not burdened by government regulation. And, of course, not just in the court, but this is filtering down all through the Trump administration. but the justices share that political goal, and that's what we're seeing.
Roberts is the Chief Justice, but his vote is just one of 9 votes. So how much power does he wield?
So a very famous lower court judge, maybe the most famous lower court judge of our lifetimes, Judge Richard Posner, used to say that the Chief Justice really has no power except, to decide who writes the opinions when he's in the majority, and maybe some administrative rules. So I have a theory about Chief Justice Roberts' vote in the Obamacare case, which is going to sound crazy to you and your listeners, which is that from 2005, when Justice Roberts became the chief, to 2012, he had no power at all because Justice Kennedy held all the power. In that first term, Justice Kennedy was in the majority of 100% of 5-4 decisions. And for the next 7 years, the court went the way Justice Kennedy went. If you check the reporting in May of 2012, April of 2012, before the Obamacare decision came out, you will see reporters saying how Justice Kennedy goes, the court will go. Supreme Court justices are human beings. They're people like us. Now, they have better jobs than most of us, but they are like us. And, Chief Justice Roberts, I think, always wanted to be on the Supreme Court and always wanted to be Chief Justice. It was the fulfillment of his, I'm not saying he thought he would ever get that, but you can't go any higher in the law than he went, and he had no power because Justice Kennedy had all the power. I think psychologically that was a factor in his decision in 2012. So the story after 2012 became, Justice Roberts is a swing vote also. Wasn't really true. Today, he has very, very little power. He has to get either Justice Barrett or Justice Kavanaugh or Justice Gorsuch to agree with him when he doesn't want to rule in a conservative fashion because he's never getting Alito and Thomas to rule with him. So I would say he has no more power than Gorsuch, Kavanaugh, and Barrett. And I'm not even sure he has more power than Justice Barrett, with the exception, and it's a big deal, when he's in the majority, he gets to assign the opinion. But other than that, his vote counts the same. And frankly, I think he was a little bit scarred in the first 7 years on the bench when his vote counted much less than Justice Kennedy's vote.
So how do you think he ranks as far as chief justices who've led the court?
Well, I think if our country gets back to some sense of normalcy eventually, but I don't think we're living in normal times, for better or for worse. I'm not going to be partisan about that. But we're living through times that are changing very quickly. But assuming we get back to some degree of stability in America, my guess is he's going to go down as one of the worst chief justices. And I say this for the following reason. History has shown that when the Supreme Court lurches far to the left or to the right, eventually the political system goes the other direction. So when the Warren Court went too far to the left, and I'm a liberal progressive who will say, I think the Warren Court went too far to the left, then Richard Nixon runs on a law and order campaign, Ronald Reagan runs on Roe versus Wade, and Republicans hold power for most of that time period in the political sphere. This Supreme Court, I think, and I think political scientists think, is far to the right of the median Republican voter, leaving aside the median Democrat voter. So my guess is eventually there will be a cycle where the political system lurches in the other direction. And then we will see just how conservative his court has been. It has been very, very conservative. And there are even conservatives today, scholars, even some Federalist Society folks, who are saying things like this disrespect for precedent is not a conservative value, right? Conservatives like the status quo. Progressives want to change the status quo. The Roberts Court has been reversing important precedents at, I think, a rate that's probably unheard of in American history. I'm not saying they're reversing more cases, but that doesn't matter because the importance is, are they reversing important cases? Guns, abortion, affirmative action, separation of church and state, separation of powers, and even federalism, which traditionally has been a very conservative value. Those areas of the law have been dramatically reshaped in 2 short decades. There's no definition of conservative that I know that suggests that judges should be the ones doing that.
Thanks so much for joining me on the show, Eric. That's Eric Segall, a professor of law at the Georgia State University. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.